Three, two, one.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Court of Appeals. I want to first tell you how much we appreciate all of you participating in this Zoom oral argument. It's not necessarily the best way to do things, but it is the best way to do things right now, we believe. It's at least the safest way to do things, and that's what we're concerned about, as well as also hearing the cases we need to hear. And we appreciate you venturing out with us as we utilize this process. I will say to you that when we start, it will be just as if we are in the courtroom here in Jackson. So the same procedure, the same protocol will apply. The appellant will have 15 minutes to make his oral argument. The appellees will have 15 minutes to make their oral argument. And as Mr. Hebner is always so good about doing, I'm sure the rebuttal time has been reserved, if there is any, for the appellant. And I would ask that the appellees, when you begin your oral argument, that you tell us how you are going to intend to share time. Before we start, though, I want to introduce our panel for today. Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Mr. Hebner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case.
Erin R. Knight versus Tennessee State Board of Education.
And we will hear from the appellant.
Thank you, Your Honor. Joseph Hubbard of the National Bar. May it please the court, I represent the petitioner and appellant, Erin Knight, in this case. I'd like to reserve 3 minutes of my time for rebuttal, please.
All right, sir.
Erin Knight is a public school teacher in Tennessee. She is licensed by the Tennessee State Board of Education. And this case arises out of the state board's proposal to formally discipline Knight and then Knight's legal challenge to the state board's authority to do so. The specific challenge to the board's authority is to one subsection of a rule of the Tennessee Department of Education and State Board of Education, specifically subsection 2C of Rule 520-2-3-.09. I'm just going to call it the rule for ease of reference going forward. But at its heart, this appeal really concerns the Uniform Administrative Procedures Act. The UAPA was passed in 1974, and it worked a sea change in administrative law in Tennessee. And perhaps some younger generations of lawyers may lack appreciation for it, but the UAPA was and remains a tremendously important piece of legislation. And its importance has not waned in the years since its passage. What the UAPA did was give the legislature the authority to transfer some of its legislative powers to state agencies. But because those agencies are operated by unelected officials and therefore are not directly answerable to voters, the power must be carefully exercised. One of the functions of the UAPA was to guard against overreach by appointed government officials. The UAPA circumscribed the authority of what unelected officials at state agencies can do and how they do it. It put limits on the actions that they can take, and it put those limits on bodies like the Tennessee State Board of Education, which are comprised of political appointees. And it did that by confining state agencies to two ways in which they may act: by policy or by rule. And the UAPA established that distinction very clearly through its definitions. And it just defined what an agency action by rule is and what an agency action by policy is. The distinction is that policies deal only with the internal operation of agencies, whereas rules may affect the private rights of citizens. That's why rules have a much more elaborate process to promulgate. And in the years since the UAPA's passage, a whole body of law developed, which established and then continually reinforced some really key principles of the UAPA and state agency power. One of those fundamental principles is that the delegation of authority, in particular rule-making authority, must be clear and express. State agencies only have the power which is granted to them. They have no inherent common law power of their own. That's taken straight from the text of the UAPA, TCA 4-5-103, subsection A2. What we're asking is for the Tennessee State Board of Education to follow the UAPA and to adhere to the limits on its authority, which are plainly reflected in the statutes. And respectfully, there really is one principal reason with a few different discussion points for why the chancellor erred when he concluded that the state board had sufficient legal authority to promulgate and enforce the rule. That reason is that the rule on which the state board relied for its proposed action against Ms. Knight was contrary to the UAPA in that it exceeded the statutory grant to the state board by the legislature. There is no statute that contained the necessary express rulemaking authorization for the subsection of the rule in question. And the beginning point for that discussion is to look to the statutory subsection that the state board itself relied upon for its actions, and that is subsection A5A of TCA 49-1-302. It's fundamental to statutory interpretation that we begin with the words chosen by the legislature. And the legislature is presumed to have chosen the words of the statute deliberately. That's a principle that's been reinforced many times, but I take that language straight from the Lee Medical versus Beecher case, the Tennessee Supreme Court case, 312 Southwest 3rd, 515. This statute contained no rulemaking authority whatsoever. The statute granted the board the authority to adopt policies, only policies governing the revocation and licenses for misconduct. Had the legislature intended to grant rulemaking authorization, it simply would have said so. Again, the policies deal only with the internal operation of agencies. So the state board did not have the authority to go on and adopt a rule that would affect private rights like it attempted to do here. It only had the authority to establish internal agency procedures. And even the board, in some sense, seems to recognize that reality now. And through the life of this case, they've pointed to a few other sections as a basis for its authority, and I'll get to those in a moment. But to the extent that the rule purported to authorize a suspension or revocation as to Ms. Knight's license, the rule is simply in excess of the state board's statutory authority as set forth in that subsection. And I think this court said it really well in the Methodist Healthcare versus Jackson Madison County General Hospital case. Again, rulemaking authority must be expressly granted, but the court went on to say the powers of an administrative agency must be found in the statutes. If they're not there, they are non-existent. That's the exact situation we face here. The state board promulgated a rule, but its power to do so is non-existent. The couple of other reasons the reasons why the chancellor erred in his analysis respectfully is that he read several other statutes together at the state board's urging to conclude that the board had the requisite authority. And the first of those is TCA 49-5-108 subsection A1. That subsection granted the state board complete jurisdiction over the issuance and administration of licenses. There is no rulemaking authorization in the text of that statute. Going back to what I mentioned a few moments ago, it's fundamental to statutory interpretation that we begin with the words chosen by the legislature. And so it's not really necessary for this court, and it wasn't necessary for the chancellor to seek to define the terms administration or jurisdiction, or to expand upon their meaning by looking to the dictionary, because the express grant itself is not found in the text of the statute. But if this court were to go on and consider what those terms might mean and whether complete jurisdiction or the term administration bestowed a sort of unfettered power to enact rules for disciplining teachers through licensure actions, the answer to that question is a clear no. And the reason is simple. To read subsection A1 of that statute in that manner would render about a half dozen other statutes and statutory subsections completely meaningless, duplicative, superfluous. And the court's duty is to construe a statute so that no part would be superfluous or insignificant. And so you just have to look in that same statute, for example, subsection C, of 49-5-108, there's a rulemaking authorization for the issuance of licenses. So if in A1, the state board had been granted the power to rule make over issuance and administration, there would be no need in subsection C to then make a specific authorization for that type of rulemaking. In D2A of the statute, there is a provision which allows for revocation of licenses rulemaking for defaulting on student loans. That would be unnecessary if A1 granted that same rulemaking authorization. There are also some other statutes which lay out specific circumstances in which teachers' licenses may be revoked. For example, TCA 49-1-607 allows for revocation on testing violations. 49-5-417 allows for revocations on certain felony convictions. And the rule in question has some other provisions, some other portions of it which actually encompass what these statutes say. Those other statutes seem to have been incorporated in parts of the rule, but it's subsection 2C that's problematic. There is no statutory grant for that subsection. But whatever the meaning of the terms are in subsection A1, the jurisdiction, administration terms mean they can't mean generalized rulemaking or even a specific rulemaking for revocation, or these other statutes would really have no meaning. And that would be, again, contrary to well understood principles of statutory construction. And really the final way in which the Chancellor erred is by looking to another subsection of 49-1-302, which is subsection A11. He concluded that that authorization was the authorization for rulemaking found its source in these combination of statutes, 108A1, 49-5-108A1, and then 49-1-302A11. And what A11 of 49-1-302 did is it gave the state board the authority to approve rules to implement policy standards or guidelines to effectuate the section. So as I mentioned before, the UAPA confines specifically what policies may deal with. They could only deal with internal operations. So the policies to be implemented by that language would be only those that could deal with internal operation of state agencies. So then the implementing rule that section allowed would have to share that same limitation. Otherwise, it would obliterate the distinction between rules and policies. But the Chancellor also erred because he went on to look to the term standards and guidelines and look to the dictionary for a definition of those. And his ruling led him to conclude that the state board could affirmatively impose requirements on a teacher through either standards or guidelines, and then that a violation of those standards or guidelines could lead to discipline by the state board. But that kind of puts the cart before the horse. It presupposed that the state board was empowered to enact or promulgate a standard or guideline in the first place, but it was not. Under the UAPA, the only way a state agency may act is through either rule or policy, and only a rule may affect private rights, privileges, or procedures available to the public. So there was no other mechanism by which a state agency like the state board could establish requirements. It wasn't authorized to adopt any standard or guideline. So whatever those terms might mean, they can't be made synonymous with the rule in terms of the specific exertion of power by the state board. And there's no need to really resort to a dictionary definition. What seems to be clear is that the term standards and guidelines enact to those which the legislature itself might enact through statute. The legislature is not subject to the same confines as a state agency. It doesn't have to confine itself to acting through either rule or policy. It can make policy decisions without delegating them to a state.
Counsel, you've used your time.
Oh, thank you.
All right, we will hear from the appellee.
May it please the court. The final declaratory order of the Tennessee State Board of Education correctly identifies the express statutory authority granted it governing the revocation of teacher licenses.
Counsel, I need you to introduce yourself before you get started.
My apologies. My name is Lindsay Cisco. I am proud to represent the Tennessee State Board of Education, appellee in this matter. And again, we submit that the final declaratory order correctly identified the statutory authority for the revocation of teacher licenses for misconduct found in Tennessee Code Annotated 49-1-302A5A, subsection 4, and the attendant rulemaking authority pursuant to that same statute in subsection A11. Pursuant to the authority, the State Board of Education has done both. It adopted policy 5.501 and promulgated rule 0520-02-03-009. And I will adopt council's mechanism to refer to it as the rule. The policy and the rule detail the conduct warranting discipline and the procedures for the denial, revocation, formal reprimand, or suspension of teacher licenses. In 2016, when Miss Knight was documented as being on school grounds under the influence of alcohol at the elementary school where she worked, the rule was in effect, and it's found on page 42 of the administrative record. The rule provides, and I quote, "The State Board of Education may revoke, suspend, reprimand formally, or refuse to issue or renew a license for the following reasons. C, being on school premises or at a school-related activity involving students while documented as being under the influence of, possessing, or consuming alcohol or illegal drugs." The board's rule on discipline was promulgated in accordance with the UAPA's rulemaking procedures and requirements, specifically notice of the proposed rule, an opportunity for a public hearing and comment, publication of the rule through the Secretary of State's website, as well as the State Board of Education's website, and ultimately annual accountability to the Government Operations Committee of the General Assembly. Pursuant to the UAPA, the rule cites Tennessee Code Annotated section 49-1-302 as the source of its authority. The entire—
Let me ask you, Cisco, what specific language are you relying on for the legislature having granted the Board of Education the authority to enact rules in regard to discipline of teachers? Because I'm having a hard time finding the language that allows that.
Well, section A11 specifically authorizes the promulgation, adoption of a rule in order to effectuate—
I read it to say adopt policies. I don't see anything that says rules. And we know from the definition section that policies are different from rules. Where is the language granting them rulemaking authority in that code section?
Section A11, 49-1-302 A11.
No, that gives them the authority to modify or adopt rules that the commissioner comes up with for implementation of policies. But it doesn't give the Board of Education specific rulemaking authorities. And we know the legislature knows how to do that because they did that in connection with teachers who are delinquent on loans. Now, why they did that, I don't know, but we know they know how to do it. So where do they do that in this code section that you're citing, specifically giving the board the authority to adopt rules, not to change some rule that the commissioner comes up in connection with implementation of policies, because that's what that section does, actually.
So section 49-1-302 is entitled Powers and Duties of the State Board of Education. And I think it needs some context to understand how the Department of Education works in conjunction with the State Board of Education, because they are appointed volunteer state servants who serve on the State Board of Education. They are not there on a daily basis. And so it is the Department of Education who acts as its arm. The commissioner is the one who actually would help draft rules and regulations for adoption by the State Board of Education. And so by saying that the commissioner may present rules, that is essentially the authority to have the Board of Education adopt those rules. You will see in the compilation of rules and regulations that all the State Board of Education rules are under the Department of Education. They are together, they are one and the same. There are no separate rules promulgated by the Department of Education. So this is how the legislature has established our state system for K through 12 education. And because it does know what a policy is, and it does know what a rule is, those two matters together require both policy and rulemaking because any licensure action of which the state board is clearly granted complete jurisdiction. And that is why the chancellor refers to 49-5-108, because the State Board of Education, in having the authority to issue the license, and is also directed in that same area for certain matters that must be addressed via discipline, mandating that revocation happen if a teacher falls delinquent on their student loans, or mandating the automatic revocation of a license for certain felony convictions and the like. That does not limit in any way the discretion. It also affords the State Board of Education to adopt the policies governing revocation for misconduct. And that is why you have a robust rule. You also have a policy so that any action that the state board takes is done pursuant to rule. Because we know, pursuant to the Bethel University matter, no action will be upheld unless affecting the rights of the public, unless it has been by way of a properly promulgated rule. And that affords protections to the teachers in our states and all affected persons. And so I think it is also important that we note the definitions of policy and rule changed after the issues here and the facts at issue here in 2016 and 2017.
And the change that you're referring to occurs where?
Later in 2017, but it certainly post-dates the issues.
And what was that change in 2017?
So the change in 2017 policy was not just limited to the internal operations of an agency. It also included its actions. The General Assembly has shored that up and tried to put more emphasis on rulemaking. They want more hands-on oversight, which is why we reference the Government Operations Committee, because every year, every state agency must prepare a list and be prepared to defend its rules and the authority upon which it acts pursuant to rule. And so the General Assembly knows what it has granted the State Board of Education. It knows that it has asked it to adopt policies and take action against licenses for misconduct. So Ms. Knight didn't petition for declaratory order regarding the validity or applicability of any statute, rule, or order regarding this idea that local education agencies have the authority to discipline state licenses. These arguments are certainly outside the province of this judicial review and not proper. But as attorneys, we can certainly understand this dynamic, that the State Board of Education issues the license, and so then they retain the ultimate authority to discipline that license, to revoke it, to suspend it in any way. That is totally separate and apart from the LEA or the employer, just like it is for us with our licenses issued by the Tennessee State Board of Professional Responsibility.
Well, then that still gets us back to, if you say that opening subparagraph is enough to give the board rulemaking authority, then why did the legislature in 49-5-108 2A talk about rulemaking authority in connection with suspension of a license for being delinquent on your student loan? Why was it necessary to use that language if they already had that authority from the earlier provisions in that statute?
Certainly do have that authority, but the legislature wanted to direct the State Board of Education that this will be a basis for revocation, and it will be by rule. That's merely a prescription to say that this is how we want it done. I don't think that there's a question that the State Board of Education as a state agency has an obligation to act pursuant to the UAPA. And that includes rulemaking authority within its statutory authority to act. So it is clear by directing in 49.5.108, by directing the State Board of Education to take these actions to revocate a license based on certain prescribed activities, that is the entity with the authority to do it. And no revocation, no formal reprimand, no suspension should take place pursuant to a policy. By promulgating a rule, teachers like Ms. Knight are protected. They have a notice of opportunity to be heard about the issues. And
let me make sure I understand your argument.
yes, sir.
You agree then that they can take no disciplinary action against a teacher based on a policy. It's got to be based on a rule. Is that right?
Yes, an action would need to be based upon a rule. That is what we learned from the Bethel University case, where, as here, that same subsection said, adopt policies governing. The state board adopted a policy on that subject matter. They acted to revoke a license, but that was subsequently overturned because it was not pursuant to a promulgated rule. It needed to, despite that statutory language, needed to be by rule and not policy. So here, the State Board of Education has clearly defined by rule the conduct that is punishable by revocation or suspension, whether statutorily mandated or within the State Board of Education's discretion. Ms. Knight's reported conduct falls squarely within that prohibited conduct, subjecting her license to discipline. She's also been afforded notice and an opportunity to be heard before any decision and any action against her license will take place. Respectively, appellant show no error in the Chancery Court's review or application of the standard of review found in 45322H.
Let me ask you, in the current version of that statute, the legislature gives the board the authority to adopt policies governing the discipline of licensed teachers. But again, even there's no express reference to rulemaking authority. Why is that?
49.1.302 was adopted in 1925. It's been amended 45 times since, and often piecemeal, but it always 49.1.302A5A, adopting policies governing the revocation of teacher licenses, has always been accompanied by 49-1.302A11 with that rulemaking authority. To the extent that a rule is required to act, the board, with the help of the commissioner and the Department of Education, may promulgate rules to that end. The rule does not limit its authority when it cites 49.1.302 to section A5A. It is the entire statute.
But if you read that carefully, it's giving the board the authority to approve or modify rules prepared by the commissioner to implement policies and guidelines of the board in connection with this section, which only gives the board the authority to adopt policies.
Respectfully, I submit that section A11 does more than that. It's more than policy-making authority. It includes express rulemaking authority, because as we've said, to act by policy would be void and of no effect.
It doesn't give any express authority to the board to make rules. It says that the board can modify, adopt rules made by the commissioner to implement policies. Is what it says.
And that is what the rule does. And that's what the rule did.
Well, if the legislature wanted to give the board the authority to make rules in connection with discipline, why didn't they just say that?
Because they've said it in different ways in subsection 11 and through the different grants of rulemaking authority as it relates to those issues.
All right.
All right, we will hear from the appellant in
Thank you,
rebuttal.
Your Honor. Thank you, Your Honor. Just a few brief remarks. As to the issue of the amendment, the questions asked of counsel are sharp in that it's not entirely clear what the legislature thought it was doing when it revised that section to grant some more policymaking authority to the state board. And it's absolutely accurate that there was no grant of even additional express rulemaking authority. The key thing with this statute 302, 49.1.302, is there just simply is no express rulemaking authorization for license revocation. There's nothing like that language is found in here. And what the state board has done is sort of tossed several statutes in the pot and mixed it around, and from that attempts to conjure an authority that's found in none of them. And that's a profound and concerning, and exactly what the UAPA is designed to guard against, that it requires specific authorizations, and the legislature very carefully grants that authority because these are not elected officials that can be held to account by voters. So I wanted to make that point, and the amendments, to whatever extent they might have repaired the state board's lack of authority at the time giving rise to this case, they weren't retroactive. So those subsequent amendments can't have granted this board any more authority than it had at the time, which was none for the action against Ms. Knight. As to the question, I think council mentioned that issuance, that the board was empowered to issue licenses and therefore could revoke them. Issuance is a ministerial task. It is no way the same as then coming behind with a complete unfettered power to revoke those licenses for whatever reasons it might choose. The legislature is the body that was empowered to make decisions about when and in what manner licenses could be revoked, and it made those decisions quite clearly in several statutes, and it made them in situations that were really not subject to the kind of fact-finding expedition and adjudicative hearing which the state board seems to believe it was authorized to do here with respect to Knight. It was testing violations, defaulting on student loans, criminal convictions, not just allegations as the state board's made here with respect to Knight. That prevents teachers from finding themselves in the uncomfortable position of having to drag witnesses to Nashville to try to defend itself. So there's some wisdom in the limited authority of revocation that the legislature granted to the state board. And whatever standards and guidelines might be violated, there are none in this section to be effectuated by the rule that the state board enacted. The section is silent as to whatever those standards and guidelines might be. So that's really a mere hypothetical as to what standards she might have violated. But I see that my time is up, so I'll stop there. Thank you.
All right, thank you, counsel. We appreciate your arguments. We appreciate you participating via Zoom with us. We will take this matter under advisement and endeavor to get you an opinion at the earliest time possible. Thank you. Mr. Hebner, if you will dismiss us until the call of the next case or recess.
The court is now in recess until 10 a.m.
Thank you.
Thank you.
Yeah.
Or you could dismiss.